Showing on this episode of Law Weekly, a conversation about the performance of the judiciary this year and the need for urgent reforms. My guest is a senior advocate of Nigeria, Mr. Emeka Opoku. Also showing on the program, the Institute of Chartered Mediators and Conciliators, ICMC, has held its 2024 conference, which had the theme, Rethinking Mediation Strategy in a Turbulent World. Keynote speaker, the immediate Vice President, Professor Yemi Osinbajo, calls for collaboration between professional mediation bodies and the public sector, especially to make mediation accessible to the less privileged. Plus our recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shuyeli. The winding down of the year provides a good opportunity to assess how well the judiciary has fared this 2024, and this is the starting point of my conversation with my guest, Senior Advocate of Nigeria, Emeka Opoku.
From my own personal perspective, I won't give the judiciary any Passmark. They've not done well. Why? The reason is that I practice law. I'm in the courtroom virtually every day. So I see what goes on. I'm not coming from outside. That's what I do on a daily basis. I still see delays. Cases are subjected to undue delays in court. Cases, people are wasting their various precious time in the court. Today, people are beginning to even look elsewhere to solve their legal problems. Things that ordinarily will go to court. You can't be sure of the court any longer. The principles of law, we used to know that we can look at any situation. If you give us a case, we look at the case. After looking at the facts and circumstances of any case, based on the principles of law we know, based on the authorities we know, based on the statutory or judicial authorities that we know. Judicial, we usually we are able to predict the likely outcome of that case. You can't do that for now. I mean, at this material, we can't be sure any longer. In fact, these days, when these surprises are coming up, there are times you'll be doing a case, they'll tell you there are people that know their way around the court. And they'll take the file away from you. And so corruption is very much on the rise in the judiciary. So you are not sure. A lot of things are happening that are really, really very surprising. You can't be sure where you are headed any longer. And it is quite very frustrating. Judiciary is supposed to be it's a serious business that we usually do there. But today, you're not sure that you can tell a client, do it this way, based on the way you have done it, this is the likely outcome in the event of any trouble. You cannot. As far as I am concerned, it started from the head, meaning that for Nigeria, it's all about the leadership. Once your leadership has that problem, the likelihood is that everywhere will also become polluted. So you cannot have a leadership that is tainted with certain impression and expect to see angels down the line. It's not going to work. It's the same thing. So it's about leadership as far as I'm concerned. Nigeria's problem is about leadership.
I hear what you say about leadership, and I want to focus on the leadership of the National Judicial Council, headed by the Chief Justice of Nigeria, Justice Kudirat Kekereekun. Only recently, the body sanctioned 5 judicial officers for various acts of misconduct. 2 heads of courts were recommended for compulsory retirement for falsification of their age. And the NJC also asked them to return all the monies they collected for staying in office beyond their retirement days. There are those who say that if you want to see any meaningful reforms, the NJC should have even recommended judges for prosecution and even championed some.
Well, I expect the judiciary to continue to sanitize it. But whether or not I have confidence, it may be too early for me to run into any conclusion. But I expect.
It's because of the system on the door.
Yes, but she wasn't part of the administrative system. She was in a courtroom and she was doing exceedingly well. And now she's now administering. So it's outside of the normal roles she was playing as a courtroom justice. But I don't have any material to form an opinion on whether she will do well or not. Because I'm not, I haven't seen her perform any administrative functions outside the functions of a typical judge in the courtroom, which I think she did exceedingly well. I'm not opposed to prosecuting them, no. But the question is, reconcile it with the NJC concentrating on the appointment of judges and ensuring that it is done in such a way that only competent hands, people who are qualified to be judges, are made judges. Reconcile it with that one and see which one is worthier and which one will add more value to the system. This one is like chasing a dead man. Chasing a man that is almost on the way out. He has become a judge, If he had caused havoc, he had caused havoc. If he had delayed dispensation of justice, he's done that. Whatever thing that ought to be described as bad in the judiciary that they had done it. So why are we not concentrating on appointment, modalities for appointment? So this is your comment. Why? Today, yes, politicians are playing major roles in appointment of judges. Oh, no, we're not talking about that. What should be the ideal set for appointment? The provision of the Constitution is very clear. The provision of the law is, the processes are in order, but the implementation is the problem. Just like one Harvard professor they call Professor Tocqueville said, for all forms of government, let the fools contend. What is best to administer is the best. So whichever way you look at it, it is not really the law or the provisions that are our problem, or that is our problem. The problem is implementation. When Nigerians allow it, Nigerians are so difficult, so corrupt. A lot of corrupt people in Nigeria, corrupt practices ongoing in Nigeria. So no matter how you try to do it, they will subvert it. And it is the subversion that is the reason for the trouble. Therefore, you may end up seeing someone who is not even near competence being made a judge. And you go before the person you are talking law, the person will be wondering what you are talking about. Or you will be wondering, does this one understand what I'm even talking about? It happens.
How do we then whittle down the influence of politicians in the appointment of judges?
It's not a difficult thing to do. But where it becomes difficult is that these things are done in the secret. And if they do it in the secret, and with the exchange of naira and kobo or dollars, will you know? You wouldn't know. So it's a very difficult thing unless the people are reoriented. That is, the persons they can easily approach. If they approach you and they say no, because you have the capacity to say no. But where you are still porous to the extent that you can be influenced by dollars, what will happen? Nothing will happen. They give it to you, still do it. Must you say you were influenced by a politician? You must not say it. The most important is that person will succeed. It's only the person, yourself, and God that knows or that know who influenced it. That's all. So it's not an easy thing. It requires a total reorientation of our people. And as long as we don't get it, the situation will continue to be problematic for us.
Now, with regards to reforms and perhaps as part of agenda setting for the new CJN, what are some of those things that you think that she can quickly do to bring reforms to the judiciary and give Nigerians the kind of judiciary that they want to see?
For me, the new CJN should concentrate, or rather should look at ensuring that the courts do go straight to substantial justice. They keep preaching, even in the law report. If you open the law report, you see it, that the era of technical justice is gone. But in reality, is it really gone? If you go to the open court, is it really gone? It may not be gone. It can only be gone when they choose that it is gone. So, well, if the CJN begins to insist that, hit on, go straight to substantial, two men are fighting over a piece of land. And one is saying, these documents, they didn't certify it. The court will definitely, because the document is public document, but it didn't, or you came with photocopy, they can refuse to admit that document. And that may run into trouble. Are you getting my point? So it's only when you are technically deep in this business that you appreciate those subtle differences and ensure that you do your own properly. Otherwise, even though you have a good case, but your good case was not, yes, technically they don't allow your own people to present your case very well, you will lose it. But the judge knows, he knows what you're talking about. So we need to, first of all, look at era of technical justice. Let it really be gone. Very, very key. Then corruption is key. It's not, let me tell you, if you're doing a case before a judge who is influenced, it may not take too long to appreciate that, to discover. Because he will just go like a loose cannon. You see them. They can come after you. They may also decide not to write or record whatever you're saying. They may descend into the arena and begin to be judges for the parties on the other side. You will know that something is going on somewhere. Are you getting my point? So, if you read a ruling where a judge who ought to know that 1 + 1 is supposed to meet, and is giving him 4 or 3.5, you should be able to ask yourself, something may have happened here. And so, yes, the point is that corruption, she needs to also take it very, very seriously. Then, taking care of the needs, the judges themselves, taking care of the needs of the administrative staff, members of the judiciary, so that you mitigate their hardship and ensure that they don't look elsewhere in bid to survive, which ultimately will rub off negatively or truncate even the administration of justice.
What about the Nigerian Bar Association? What can the NBA do in terms of reforms? Because we also have a new president of the Nigerian Bar Association. Whereas with the judges, we saw that the NJC moved against those judges and sanctioned them. But we've not seen any corresponding action on the part of the lawyers, because some lawyers appeared before those judges to make those submissions. A case is already been decided, and then you go before another judge to canvass same position so that you can get a judgment that's favorable to you. We've not seen any corresponding action on behalf of the Nigerian Bar. So what can the NBA do in terms of championing reform?
NBA, at most, is a pressure group. It's a pressure group. We can talk, we can give pressure, yes, but it's a pressure group. It can't go beyond that echelon. It's a makeup of lawyers. That's an association of lawyers called the bar in Nigeria, and that's all. It can't go beyond that. No matter how you try to accentuate it or build it up, still a pressure group. So what they are doing, or what we're doing as a body, is the best we can do. And I think we're doing it well, because we can make noise, we can talk, we can fight, we can even as a group go to court if we see any cause of action to challenge certain issues. Well, the NBA is made up of lawyers, therefore we must see a cause of action before we go. If we didn't see a cause of action, and then we must be sure that it is so that we have locals to do. But mind you, a lawyer is an advocate. So he goes to court and presents his case. If he presents, it is the duty of the judge can say, this is foreign shopping, I refuse. Although that what they do is that they won't even make the judge know about the existence of this or that decision. They won't let them, the judge will not know. But if the counsel on the other side brings it out, of course, it is the duty will now fall back on the judge to say, in the light of this other case, you can't do this before me. Are you getting my point? But minus that, why are you going to punish a lawyer who files his case? If it is on foreign shop, yes, you can catch up. That can catch up with any lawyer.
Yeah, this is such long tour.
No. The NBA will not take you unless a report is made to it now.
Why was the NBA with for reports?
Because
obvious that
unless the NBA decides to call, the property is that there should be a complaint. A complaint.
How you?
No, anybody can. You can complain. Anybody can complain. He can complain. Anybody can complain.
Where should champion it? What's it?
No, but if you complain, they will champion it. It's just like criminal cases you see. Somebody must be the complainant. Once the person is no longer there, or avoiding it, or did not complain, even the court will be tired. There's nothing the court of law will do. Who will you listen to prove the allegation? Would you just say, oh, because they are lazy? Yes, no. They will be subjected to trial. And who is going to enter the witness box to prove it? Is it not somebody? And so, That's why a complainant must be involved. Let the person complain.
Welcome back. The immediate Vice President of Nigeria, Professor Yemi Osinbajo, has called for a deeper collaboration between professional mediation bodies and the public sector to make mediation of cases more accessible for the less privileged. He made this comment in his keynote speech at the ICMC ADR 2024 conference, which held in Abuja.
Ladies and gentlemen,
many schools of thought believe that alternative dispute resolution remains a reliable approach to easing the burden on Nigerian courts. To make this happen, the Governing Council of the Institute of Chartered Mediators and Conciliators, ICMC, is hosting its annual conference to equip members with the skills to become peace builders and leverage mediation as a tool for resolving conflicts, including those between communities.
Important mediation conference.
Former Nigerian Vice President, Professor Yemi Osinbajo, participates virtually.
Distinguished and noble panelists.
Participants acknowledge the significant contributions of professional mediators to fostering peaceful coexistence in Nigeria and beyond. They express optimism that the discussion at the conference will generate new strategies to promote global peace.
Africa, Nigeria, is better because of the great and magnificent strides of professional mediators in promoting peaceful coexistence and effective justice delivery system.
Mediation continues to play a key role, as can be seen in some current and ongoing global conflicts across the world. In order to meet the demands of a turbulent world, we must adapt our mediation strategies in several ways.
Speaking virtually, Professor Yemi Osinbajo advocates for collaboration between the institute and the public sector to ensure that underprivileged individuals in need of mediation services can access them.
In the search for more affordable mediation, we must work with the public sector. Access to mediation by a citizen should be guaranteed. A few years ago, as Attorney General of Lagos State, we established mediation centers as part of our Citizens' Rights Department. The objective was to make mediation services accessible to all, especially for small claims.
a lot of our problem comes from the fact that we don't really go into the roots of the problem. Now, when you're talking about adaptive mediation, you're really talking about being flexible and realizing that it isn't about one size fits all. You have to focus on the end result, and you have to realize that you have got to be the one that is constantly moving around in a way that you will get the end result, and the end result is peace. We need to think in terms of adaptability. Do we need to bring in other persons? Do we need to bring in other contexts?
It is obvious that we are saying we have to enhance the strength of mediation, which is the best of all the species of ADR. Mediator must understand the attitudinal disposition of the disputant. 3, he must possess the necessary skills to put and maintain the disputants within track of conversations central to arriving at a solution. That's where sensitivity comes. The mediator must be environmentally sensitive and must be able to sense and perceive any attitude that could drift into emotional outbursts.
My final take at this stage is that decolonial praxis, not decolonization, but decoloniality, emphasizes the need to rethink not just the strategies of mediation, but the construct of mediation itself. To delink that epistemology inherited from the West and relink with African ancient indigenous systems in which knowledge is produced to serve our purposes in economics, in environment, in law, in culture, religion, etc., etc. If we're able to overcome the present limit situation of taking ADR as given and refashioning it in a regional African context, maybe some of the crises and conflicts we have today may be better attended to and better resolved than the current way we are doing it.
As the ADR conference concludes, participants are confident that embracing innovative mediation strategies will contribute significantly to building a peaceful and equitable world.
And just before we go, a quick look at some of the major court stories we tracked this week.
We begin with the report that the arraignment of the former governor of Kogi State, Yaya Bello, at the Federal High Court, Abuja, was stalled on Friday as the trial judge, Justice Emeka Nwete, turned down the application of the Economic and Financial Crimes Commission, EFCC, to arraign the former governor in the absence of his lawyers. Delivering a ruling on the oral application by the EFCC's counsel, Senior Advocate of Nigeria, Kemi Pinheiro, the court held that such request could not be granted in the interest of fair hearing. Justice Nwete agreed with the senior advocate that though a bench warrant was issued against the former governor, fair hearing cannot be sacrificed on the altar of bench warrant. He subsequently adjourned the case to December 13 for hearing on abridgment of time and possible arraignment. Another judge of the Federal High Court, Abuja, Justice James Omotosho, has acquitted and discharged no fewer than 50 persons alleged to be members of the proscribed Indigenous People of Biafra (IPOB) of allegations bordering on terrorism. In his judgment, Justice Omotosho held that the Nigerian police force failed to establish a case against the 50 defendants, including 4 women. Justice Omotosho upheld the no-case submission of the defendants, said the prosecution failed to adduce any credible evidence linking the defendants with the allegations they were charged for. The judge consequently struck out the 3-count charge preferred against the defendants. The Inspector General of Police had sued the 50 defendants after acting on a tip-off of intelligence gathering which intercepted and arrested the suspects by the officers and men of the Nigeria Police Force, Anambra State Police Command. A federal high court sitting in Abuja has admitted there were 109 foreign nationals allegedly involved in cybercrimes to bail in the sum of 1 billion naira. The suspects were all pleaded not guilty to the 6-count charge preferred against them, but granted bail on the condition that they produce 5 sureties to the sum of 200 million naira each. The sureties must also be resident in Abuja with landed property worth 200 million naira. Justice Ekerete Akpan further ordered that the defendants and their 5 sureties must submit all their original traveling documents with the court registrar and must not travel out of Nigeria throughout the period of the trial. The defendants and their sureties are also to submit 2 copies of their recent passport photograph with the court. Pending the perfection of the bail conditions, Justice Akpan ordered that the males among the accused persons be remanded at the Kuje prison while the female ones are to be kept at Kefi prison in Nasarawa State. The defense counsel, Mr. Ogu Onoja, however, expressed optimism that his clients will meet the bail conditions. And back here in Lagos, the 7th prosecution witness, John Adetola, who is testifying in the case against the former governor of the Central Bank of Nigeria, has told the State High Court sitting in Ikeja how he collected the sum of $400,000 on behalf of Mr. Godwin Emefiele. Adetola, who identified himself as an executive assistant to the former CBN governor, also narrated how he handed over the money to Mr. Emefiele. He told the trial judge, Justice Roman Oshodi, that the functions of his office includes managing office correspondences, attending to visitors, and any other tasks as assigned by his boss. He said these duties gave him direct access to the former CBN governor. Speaking about the $400,000, he testified that in 2018, the personal assistant to the CBN governor in Abuja, Mr. Eric Odo, sent him a message to go collect the money from John Ayu, the former director of ICT department, and give same to the former CBN governor when he came to Lagos. Justice Oshodi has adjourned till December 10 for the cross-examination of the witness. And we round off with the report that the Court of Appeal in Lagos has acquitted and discharged the medical director of Optimal Cancer Care Foundation, Dr. Olufemi Olaleye. The court overturned the decision of the Lagos State Sexual Offences and Domestic Violence Court, which had sentenced Dr. Olaleye to life imprisonment for defiling his wife's 16-year-old niece. Justice Olukayode Bada, who read the lead judgment, which was adopted by the two other justices of the panel, held that the trial court erred in convicting Dr. Olaleye based on tainted and unreliable evidence of his estranged wife, Oluremi, and the alleged survivor. The other members of the panel were Justice Zainab Abubakar and Justice Abdulaziz Dogo. The appellate court agreed with the submissions of Olaleye's lead counsel, Senior Advocate of Nigeria, Kemi Pinheiro, who insisted that there were material contradictions in the evidence gathered by the prosecutions which should not have been relied on by the lower court.
And that's the program for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shele. Thank you for watching and see you next week.